Dexter Johnson to the table as well.
Thank you very much.
Dexter, welcome. We did ask you to come, obviously not for any advocacy, but rather your best understanding of this question that has, I remember a last session, not with the same advocates, about whether states do have the ability to limit the scope and subject of a constitutional convention if it is convened in this fashion. Could you address that for us, please?
Sure. Chair Golden, Senator Girard, good afternoon. Dexter Johnson, Legislative Counsel. And, well, first of all, let me say the short answer is yes. I think states do have the ability to do so. So I think I concur with the individual on the phone. And my thinking on that actually has changed a little over the past couple of years. So I do think that that states have the ability to do so. And I can get into that. One question, just want to get a sense of the committee. Do you want me to lay out Article 5 structure a little bit more, or?
I think a bit. I think a minute or two on that would be helpful.
Okay. So Article 5 creates two separate procedures for amending the U.S. Constitution. The first of those is by Congress proposing and then states or state conventions ratifying that proposal. And the second is by states proposing by applying for a convention, an amendment convention. And the idea of the framers of the Constitution when they drafted Article 5 was to make those two procedures parallel and independent so that Congress can propose amendments and states without Congress, other than in a purely ministerial role, without Congress can also propose amendments. And it's that second process, that's the one you're asking about. And the framers created this parallel structure whereby a proposal is made by what I would call substantial consensus. That is to say, 2/3 of something agreeing. And in first, the congressional method, it's 2/3 of both houses of Congress agreeing, one, that there's a need for constitutional change, and two, this is the change we're going to propose. And in the parallel and equal state convention process, it is 2/3 of state legislatures saying, yes, there's a problem, and we are proposing an amendment to fix the problem.
And so for our purposes, 37 states.
2/3, I think, is 34 states.
Is my math, is that right?
34.
Yeah.
Okay, great.
38 for 3/4 to ratify, 38,
Yeah,
34 to call.
The ratification process, which is the second level down, is where you have 3/4 of states or state conventions. And so those are the second level of Article 5. Again, two separate procedures. Congress does get to call whether it's the ratification goes to the state legislature or to the state convention. But that's a separate process. You're talking about the proposal process.
So were 34 states to pass legislation like we're discussing for Oregon here, a convention would have to be convened, is that correct?
Correct. Okay. So Congress does not have any, Congress in that capacity is purely, has a ministerial role. And yes, there is some judgment that they exercise in deciding, okay, are there 34 applications that are on the same subject? But assuming that threshold is met, then Congress must convene an amendment convention. That process has never been used before. So there is uncertainty here, and I'm not going to shy away from that. There is uncertainty, but because it's never been used. But there are, I think, I agree with the caller that there are sufficient political tools built into Article 5 to ensure that if a convention, an amendment convention, if enough states apply for it, it will be called and will be limited to the purpose of the amendment. And those political tools are, one, Congress, because Congress has to, the caller is correct that there are way more than 34 applications right now pending before Congress. Congress has exercised judgment that no 34 are on the same subject. But at some point, if enough states are applying with specifically identified subjects, there will be 34, and Congress then must convene the convention.
And state legislatures in this process need not offer any wording of what the amendment would say or anything like that, merely the topic for which they're calling for a convention.
Chair Golden, that's correct. They really just need to address the topic. And there are commentators that actually say that if a amendment application from states is too specific, that that Congress will take that into account, but that doesn't then necessarily bind the convention that is convened from going through the deliberation process and developing something that is within the subject, but nevertheless varies from the text or specific instructions that states have called.
So if this eventuates in a convention, in the course of the proceedings of that convention, who would judge the question? If someone challenged whether a proposal within the convention was within the parameters of why it was called, who would make the judgment on that it's proper and pertinent to this convention, or it's outside of the parameters of this convention?
At that point in time when it is being deliberated by the convention, it would be the convention delegates. And here, I think this is another one of the tools that states would use to limit the convention. Delegates are going to be selected by states, and this is much actually like, I think, analogous to the Electoral College process. Technically, Electoral College members representing states, they can choose whoever they want to, but of course you don't select Electoral College members that are likely to do that. And so the delegates that are selected are likely to be those that are going to limit the convention proposal to the subject for which the convention is convened. Similarly, the convention rules, which are adopted by the convention, I believe, also can and are likely to limit the subject of deliberation to the subject for which the convention is convened. The reason the founders built this convention process, because there was actually, when the Article 5 was debated, there were proposals that would have allowed state legislatures to propose amendments directly, and the framers rejected those proposals. They wanted the ability of the convention to have a robust discussion about whatever the proposal was before it went on for state ratification. And this was significant to the framers, and I think is an important point. Delegates to the convention include both those representing applicant states and those representing the other states that didn't. So you're going to get different views in the convention deliberation, and the idea is to flesh out whatever the proposal is so that it is more robust. And then finally, once a convention determines, yes, this is the amendment we want, that doesn't make it a part of the U.S. Constitution. Instead, it has to go to either it goes to either state legislatures or state conventions. That choice is made by Congress. And 3/4 of whichever method it is, legislatures or conventions, 3/4 of them have to approve it. And at that point, it becomes a part of the U.S. Constitution. So again, a state that applied for a particular an amendment on a particular subject and then gets something else, it is very likely they would withhold their ratification. And because you have an even higher threshold in the ratification process of 3/4, withholding ratification is a really significant check on ultimately some extraneous amendment getting ultimately to be a part of the Constitution.
Okay, and then
May I add a couple of points on that on that question, please?
Mr. Fieldman, one second, please. 1 minute, please.
Sure.
To return to the core of this, your view is that there is a very strong legal basis that were Oregon to pass a joint memorial that says we call on the Congress to convene a constitutional convention on the topic of XYZ, and that led to the convening of a convention. That convention could not take up issues other than XYZ.
Mr. Chair, I think that's, yes, that is my conclusion. I would put it a little bit more differently, that the convention would not take up other matters because of these political processes that I outlined.
Okay. Before we leave, Mr. Johnson, Senator, do you have any questions?
Not for Dexter, no.
Pardon me, I'm sorry.
No, I'm good with Dexter.
Okay.
I've been over Article 5 stuff numerous times.
Okay.
Yeah, sometimes we might want to do a balanced budget amendment like this.
Yeah, we had visitors on that line during the session. Mr. Fieldman, did you have any closing remarks?
Yes, I just wanted to first thank Mr. Johnson for that excellent analysis. I agree with everything that you said. I just wanted to add a couple of points on that last question that you answered. There are a couple of additional protections. One, which I had said in my remarks, which was that Congress could arguably refuse to send anything to the states that didn't conform with the mandate of the convention. And then also there are a number of cases, most recently in Florida, in the Florida State Supreme Court in 2008. It's Ford v. Browning, in which an analogous case where the delegates arguably exceeded their mandate. They believed they were within their mandate, but there was an argument made to the state Supreme Court that they exceeded it. The state Supreme Court found they did exceed the mandate, and so there was an injunction, and it was not allowed to be sent for ratification. And there's a number of those cases historically. There's only one recently, but there have been a number of similar cases where the courts have applied that kind of direct check, and there's good reason with some Supreme Court precedent to think that the Supreme Court would act in the Article 5 case in a similar way to the way the state courts have done it in their analogous situations.
Thank you. Thank you. Thank you very much for your time this afternoon. We appreciate having you here.
Thank you.
With that, I am going to close this informational hearing. Thank you, Mr. Johnson. Thank you as well for attending. And